Off we go. Okay. Welcome, everybody. Uh, my name is Tony Saramatis with Truly Wow. We are ARA's marketing and communications partner. And I'd like to welcome you to ARA's Continuing Education Series webinar for November 2024. We are thrilled to have Amy Bednar, owner of Relentless Recovery and ARA board member, alongside Marc Doumbas, Esquire, in-house counsel for Relentless, to cover breach of peace from an agent safety perspective. And before we get rolling, I just wanted to cover a couple of quick housekeeping items. Number one, I've got everyone muted to try to keep background noise to a minimum. It can get a little unruly with so many people on the webinar, and we're also going to save some time at the very end for some Q&A, probably 15 or 20 minutes or so. So please be sure to use your Q&A button at the bottom of your screen to ask a question, and we'll queue them up. We'll keep track of them, and we'll take them in order after Marc and Amy finish up. So this is probably going to be a little shorter than normal. So we're going to give you back at least a few minutes at the tail end, I suspect. But with that said, let's get rolling. So Amy, go ahead and take it away.
Sorry, I was muted. Thanks everybody for joining us today. So our goal at Relentless is compliance and agent safety. So Marc and I want to take this opportunity to share our knowledge and educate the industry today. So I'm going to go ahead and hand it over to my in-house counsel, Marc, and colleague to get us started.
Hello, everybody. Marc Doumbas speaking here. Today we're gonna cover breach of peace. One of the most broadly applicable restrictions for a creditor to use self-help in a repossession, they must not breach the peace. So that's the golden rule that we're going to talk about today. And what are our objectives today? Obviously, I think anybody in this industry understands whenever there's a potential breach of peace, we're trying to prioritize agent safety. We're also trying to minimize legal risk and consequences of a breach of peace, and also at the end ensure fair compensation for agents who have found a vehicle, have maybe even lifted it, had it in the air, and had to drop it because of a breach of peace. And we feel that our agents and companies should be compensated for that. Okay, so what is a breach of peace? Well, some of you may or may not know, but there's something called the Uniform Commercial Code, which is a federal statute, and the drafters of that never defined what a breach of peace is. So we'll try to do that today to the best we can. So what is a breach of peace? Well, there is no consensus definition of what a breach of peace is in a repossession context. However, we can fill in those gaps. So one definition of breach of peace is derived from criminal law. So you can see on the screen yourself, it's a violation of public order, disturbance, tranquility, an act or conduct inciting violence, or tending to provoke or incite others to break the peace, to include any violation of law enacted to preserve peace and good order. So, for example, I think it would be a safe assumption, anytime there's a criminal act or violation of criminal statute, it's always going to be a breach of peace in that context. On the other hand, there's many examples of breach of peace which may not arise to a criminal law or a criminal violation, but they will be a breach of peace in this context. And maybe you can say on the civil side. And what I mean by that, obviously, there's a criminal side, there's criminal penalties. They can take away your liberty and fine you. In a civil side, they can just take your money. They're not going to take your liberty. But by taking money, they're taking your liberty, right? So we're going to play a video here. And this will be an example of a breach of peace in real time.
Wow.
Okay, so that's a video taken by a citizen. Um, Obviously, I think anybody in this industry knows that's not a proper approach to trying to do a repossession. And this would be a good example later on that we can talk about. All right, so what constitutes breach of peace? There can be several things. Here we're going to discuss physical force. So all of these examples come out of case law, okay, from all over the country. Grabbing keys and making contact with someone's hand, arm, or body during repossession. Pushing a car door open or closed and making bodily contact with the individual. Lifting a vehicle when someone's inside. Entering a vehicle when someone's inside. Physical altercation with any individual. And as a caveat, you never place your hands on a customer unless you have to. You have no choice to defend yourself or your safety, and there's no path to flee. But otherwise, general rule is agents have a duty to retreat, to de-escalate, and to get out of there safely. Another example of breach of peace could be property damage. I'm sure a lot of you have encountered this with complaints that you'll get. I love this example because you can see where a vehicle went off the side of the road in order to complete a repossession. That happens a lot, not much so often in our case. It's relentless, but it does happen. So any excessive damage to lawn or landscaping, any damaging acts to a home, the awning, the siding during a repossession. We've actually had some complaints in the past where an agent has nicked the siding on a narrow driveway in an old neighborhood or taken down an awning trying to pull a vehicle out of a narrow driveway. Of course, one of the other obvious things is you damage the collateral during the recovery. These have all been examples that courts have found to be breaches of peace. So, we try to avoid these things, take our time, pay attention to what we're doing. And in our case, when we get these complaints that go no further than a complaint, we'll send the agents out to repair the damage they caused. And I've noticed that once the agents had to go out and repair this damage, they stopped going over lawns. So that's something to keep in mind when you're training your staff. Threats of violence by agents, that's another example of a breach of peace. So any verbal threats of violence or inciting violence, any conduct creating any risk of injury. So let's go back to that previous video. That's a perfect example. It's in a public place. It's in a parking lot of looks like a mall or shopping center, I should say. Obviously, there's people, you can see people in the parking lot. By driving the way that agent was in that vehicle, he's creating a risk of injury, even though no injury occurred. So that's a perfect example of conduct that creates a risk of injury, which is a breach of peace. Any kind of violent, abusive, or intimidating language. Putting a debtor in fear of immediate physical abuse, or they're provoked to violence to protect their property interest. I mean, obviously, anyone that's been in the field understands we meet people at their worst when we're taking their vehicle and they're capable of doing anything. So these are things that are no-nos that are always going to be a breach of peace that we need to avoid. The big one and most obvious one is the debtor objects to the repossession. So, for example, the debtor verbally objects to the agent repossessing the vehicle, a breach of peace has occurred. So if the agent, over the objection of the debtor, takes the vehicle, that is a breach of peace. You can't do that. Now, obviously, in certain situations, we understand that a good agent's able to talk that person into possibly getting the vehicle. Obviously, you're going to know within the first 20 seconds if you're going to be able to get that vehicle or not. But at the end of the day, if they're objecting, they're persistent, you do not take the vehicle. Objection of a third party, even if the debtor is not present. This could act as a objection just as if were the debtor himself there. This probably would occur, at a place of employment. We've had these where you're in a parking lot of a business or employer, other coworkers are outside smoking or on break, and they see you taking the vehicle, and they all come over and object or block you in. It's the same thing if the debtor's doing it. That's a breach of peace. You can't take the car. This is a common one. Obviously, you're out in the field. You're either backing up to the vehicle or trying to back out. The debtor stands between the vehicle and himself, or between the boom and the vehicle if it's hooked, preventing the repossession and preventing the agent from leaving. Obviously, this is a breach of peace. It also creates a serious safety risk if the agent continues to pull forward or drive with the debtor between the collateral and the vehicle. And I've had this personal experience. I've had agents call me. They're on the phone with me. The debtor's on the phone with the lender. And of course, you know what goes down there. The debtor's trying to pay good, so the vehicle's not taken. And when they can't, the lender will literally instruct the agent, go ahead and take the car. You can't take the car because they're objecting, and it's a breach of peace. Just the fact that the lender said take the car does not absolve you or change the fact that it's a objection and a breach of peace. And this is a perfect example of, you've got to know more than your lenders. And in some cases, they know less than we do because we're out in the field every day. So just because a lender tells you it's okay, do not take that car, because you're setting yourself up for a lawsuit. And obviously the lender's setting themselves up for a lawsuit. This is another one, which I'm sure some of our seasoned agents know. Whatever local community they're in, if they feel they're going to have a problem with the recovery, or they know ahead of time that if they get the police involved, the police will tell the debtor to surrender the vehicle and they can take it and bring it on back to the lot. Well, anytime law enforcement shows up at a repossession scene, it's always going to be a breach of peace. It doesn't matter who called them. The debtor called them, you called them, the neighbor called them, or they're just driving by and stop, or they live next door. Anytime the police, law enforcement shows up at a repossession site, it's a breach of peace. You cannot take the vehicle. And if you think about it, there's going to be a public record. If the police are there or they're called there, they're most likely going to generate some kind of report or police report. There's going to be a public record, and the attorney's going to grab that police report. He's got direct evidence that their law enforcement was involved, that there's a breach of peace, and that you took the car, and you're going to be sued. So do not ever, in any circumstance, take a vehicle when law enforcement's present. Now, obviously, there might be situations where you need the police involved. Maybe the agent's assaulted. They've damaged the collateral. They've damaged our vehicle, or again, they've assaulted the agent, and that's brandished a weapon or used threats of force. That's an instance where you might, for agent safety or for property damage, you'd want to call the police to document that, possibly even have that person prosecuted because they've damaged your property. And but then even in that situation, you did not take the vehicle. Even if the officer says take it, do not take the vehicle. This is just the golden rule. Do not do it. And a little bit of background on this, the legal side, they call this color of law. And what it is, if the police show up and assist the repossession agent in completing a repossession, it's you violated their civil rights. It's under the 1983 action. I'm sure some of you have heard of that, especially in this day and age. Usually that's involved with police brutality or some type of civil rights violation of an individual's right. Well, this is what this is. You're violating the civil rights of the debtor if you take a vehicle and the police have assisted you. So that's the background on that. So don't ever do that. Okay, so what are the best practices? When is a repossession complete and no breach of peace can occur? So case law, again, there's no definitive answer. Every jurisdiction may have a little different rule or rationale on it, but the golden rule is, the further you get away from the repossession location, the better off you are. I know a lot of times agents will take the vehicle down the street or even right out the street. That's not far enough away. Maybe 1 block away may not be far enough, but maybe 6 blocks will be. Maybe 10 blocks would be better. So your agents need to consider this when trying to finalize the recovery, when they're going to strap it down, when they're going to do their condition report. The further away they are from the repossession location, the better off you're going to be. And obviously you've all experienced this, or your agents have. You're securing the vehicle and the debtor shows up. And again, look to the first paragraph. How far are you away from the repossession? It's going to be fact specific, especially if it leads to litigation. So the further away you are, the better off you are. If they show up at the lot, too bad, so sad. Once you have that vehicle to your lot and the agent or the debtor shows up objecting, it's not a breach of peace. If you're 20 miles away on the highway going back to the lot and they show up on the highway, that's not going to be a breach of peace because you're further enough away from the scene of the repossession. And the rationale behind this, behind the court saying this, is there's always potential for immediate physical violence that continues until the repossessor has moved the collateral to a site that is under the repossessor's control, or at least well outside the debtor third party's range. So the further away, the better off you are.
I think I'll add to that too. It's really important to implement a company policy where if the driver has to, check the straps on the vehicle or safety chains, or just kind of regroup, try to do it as far as possible from the scene of the repossession. Do not go to the gas station right around the corner and do it, because there's a greater likelihood of a breach of peace occurring, or even a violent action happening with him.
Yep. And it is probably a good idea, the further away you are, when you finally do feel comfortable to stop and secure that vehicle, that it's in a public place. That's probably helpful as well. All right, so we have another video here of a breach of peace we're going to watch.
First at 11, a Port St. Lucie man is behind bars tonight, accused of shooting a man who was trying to repossess his car. Good evening, I'm Felicia Rodriguez.
I'm Todd McDermott. Thank you for joining us here at 11 o'clock. It happened just after noon today in a residential neighborhood. Ari Height reports from the scene tonight with a video of what happened just before the gunfire.
According to Port St. Lucie police, this all started when a man came to this home on Southwest Villanova Road to repossess a car. The guy inside the house came out, confronted the man. Things got violent, and that's when a neighbor grabbed her phone and started recording.
Get out! Get out! This is private property!
According to police, the man yelling in the video is 59-year-old Omar Sukwe, trying to stop someone from repossessing his car.
Hey! Hey! Hey!
This video was shot by a neighbor who has asked us to conceal her identity.
I came outside. I heard a bit of a ruckus. The homeowner struck the tow truck driver in the face and then went back into his garage.
At that point, the truck driver jumps out of his truck and follows Sukwe toward the garage, the two men constantly yelling at each other. And that's when the neighbor stopped recording. She went inside to her own home to make sure her family was okay. But the yelling continued, so she came back outside.
That's when I saw him come out of the garage with the gun and saw that happen.
The suspect exited the residence and at one point armed himself with a handgun and shot the victim multiple times.
I heard 4 gunshots. 1, 2, 3, 4.
Police say the victim was able to drive down the street a bit and have a neighbor call 911. His name has not been released. Police say he's 28 years old and is expected to survive. Officers say Sukwe was waiting for them when they arrived at the house to take him into custody.
I just can't believe this would happen in our neighborhood. You feel safe, but obviously you don't.
Omar Sukwe now faces 2 separate charges: attempted homicide and aggravated battery with a deadly weapon. He is currently in the St. Lucie County Jail. In Port St. Lucie, Ari Height, WPBF 25 News.
So everyone saw that video. You can see the debtor's outside. He's between the collateral and the tow truck. The agent disregards that, continues to back up over his verbal objections. You can see him. He's actually on the boom. He's sliding it, trying to slide it under the tires. That's about as reckless as it could ever get in the field, where an agent should never have done that. And of course, as you see, it's on video. And that's another caveat that we didn't really talk about earlier. There's cameras everywhere. I mean, there's cameras on most of your trucks. There's going to be some agents got body cameras on. Residents or debtors are going to have cameras at their home. There could be the neighbor's camera across the street, or there's going to be a neighbor with their cell phone filming this. So at all times, you've got to assume you're going to be on video. So anything you do is going to be direct evidence of a breach of peace or violence or whatever you want to describe it. What that agent did there was reckless and was uncalled for, and almost cost him his life, because then it caused the debtor to get violent because this agent wasn't backing off, and he goes and punches the guy in the face. And what does the agent do? Instead of retreating, he gets out of the car to go fight the guy, apparently. And again, he's lucky to be alive. So this is, this had a lot in it. And, obviously this is the worst of the worst you can find, but you got to train your agents. They cannot engage people under these circumstances. And I believe it was in Louisiana within the last year or two, there was actually a fatality shooting where the debtor came out, the police arrived, and at the end of it all, the agent took the vehicle. So you had everything there and color of law. So again, this is an extreme example, but it happens. It happened here. It could happen anywhere. So remember that. Okay, so what are the best practices to ensure agent safety? Amy's going to take over at this point, and then we'll get to the question and answer section.
All right, so I'm going to share what we've implemented at Relentless Recovery, and these are best practices for preventing breach of peace and ensuring agent safety, and that is by implementing a compensation policy. So if an agent is forced to drop or leave a vehicle at the recovery scene due to a breach of peace, a potential breach of peace, or threat to their safety caused by the debtor or a third party, make it a company policy that the agent will be compensated for the repossession if all of the following apply. If the agent provides a written statement of facts to be reviewed by management, and I can go ahead and share the online form that we use that I'll be glad to share with all of you, so you can implement this within your own agencies. The management reviews the video footage for corroboration, and this last piece is that an invoice for the full repo is sent to the lender. So this is where we're asking for our lender partners to participate with us in this initiative. So this is an example of our policy at Relentless. It ensures that agents are compensated in the event of a threat of safety during the repossession process. And our policy is designed to incentivize responsible and safe conduct by our agents, discouraging them from taking unnecessary risks. By providing the compensation in these cases, we prioritize safety and professionalism, and it ensures that our agents provide peaceful resolutions over conflicts or dangerous situations. So this is a portion of the form that we use. And once again, I'll be glad to help anyone by sharing the platform that we use and the way that our process is to get this out and report it as soon as it occurs. So it's important that you list the type of safety risk. So you can see our drop-down screen, drove off the lift, blocked in by a debtor or a third party, violence or violent threats, a firearm brandished or firearm threat, and police involvement. We ask for a photo of it. Well, if you did hook it, photo of it, or even just a still footage of the video, and then a brief description of the incident. So I think right now we're going to open it up to the Q&A, and Tony is going to go ahead and get us started on that.
Yeah, right now we don't have any. Does anybody have any questions for Mark or Amy?
I see one in here on.
Oh, there we go.
This is I have a direct message actually. I'll go ahead and I'm going to go ahead and is tailgating entering without permission into an apartment? Oh, I mean, I just lost it because we got some more questions coming in. Is tailgating entering without permission into an apartment parking garage a breach of peace, or is it considered breaking the law? So that would be an apartment parking garage.
Right. I can jump in here, Amy. There's actually case law on that. There's going to be a couple factors you look at. Is it a secured parking lot with a gate or a key pass to get in? Or is it open to the public? If you have a situation where it's a secured lot, you need a pass to get in, then yes, most likely it's going to be a breach of peace because it's going to be a trespass. it's sort of in that situation. Now, if it's an open parking area of an apartment complex versus a garage or a secured parking area, then you're going to be okay going in there and taking a vehicle out.
So, Mark, I think the actual question was, is it a breach of peace or is it a trespass? Like
Right.
and
Well,
is there-
they're one and the same. So a trespass is a breach of peace. So, if you go back to what we talked about, physical force, property damage, threats of violence, those are all breach, police showing up, that's all breach of peace. So yes, it would be a trespass to walk in or gain access to a secured facility. I know in the past, agents would wait for the gate to go up and sneak in to get the vehicle out. You're setting yourself up for potential lawsuit in that situation. You got to remember, there's probably cameras on that parking garage or in the complex. If they see you come in and come out with the car, you're going to have a problem. So that's going to be a case by case situation on where you're at. Obviously, a lot of the parking complexes have open parking lots. You're going to be fine there. Now, on the other hand, we've had situations where places of employment or even some businesses or even apartment complexes, if they have security or someone there that basically says, hey, you're not welcome here, they give you a trespass warning and you go back, that will be a breach of peace and you could be prosecuted for trespassing. So that'd be an example of a criminal violation that's a breach of peace, and you're going to have a problem.
All right. Emily is asking, in requesting repossession fee to be paid by the lender, we're seeing lender policies requiring a police report in order to pay the fee. Thoughts on this being a requirement? The concern that this creates increase in calling police, or the potential for breach of peace with law enforcement present.
So I apologize, Tony. Could you restate the first part of the question?
Yeah, in requesting repossession fees to be paid by the lender, we're seeing that lender policies are requiring a police report in order to pay the fee. Thoughts on this? Are there any?
I'm going to let Mark
Yeah.
answer the second part of that. But the thing that comes to mind is that if a debtor is objecting to the repossession and we leave the unit in order to prevent a breach of peace, that is not something that we would make a police report for. However, we're incentivizing our agents to have responsible behavior and not breach the peace. So, Mark, I'll let you go ahead and jump in.
And I think, as all things in this industry, we've got to educate the lenders on what's going on. We've got to get them on board with this. That this is about agent safety. It's about, even protecting the collateral. When they drive it off a lift and damage it, that doesn't benefit the creditor. But it's just illogical that you would drop, you're doing your own in-house reporting. You're creating a system to bring in the facts, the reason why the collateral was left and for the breach of peace. And you're also, leaving the vehicle. You're avoiding a lawsuit. You're avoiding legal consequences by doing this. So we're going to, as an industry, we've got to educate the lenders on this so they understand. Because, most likely the police aren't coming out, or if they come out, it's going to be an hour later. And what good is that going to do you when you could be out recovering other vehicles? So once we get lenders on board with this, and as an industry, every person who's a business owner here or employee with a repossession company implements these policies and starts submitting them, then we can gain an advantage and educate them and continue on.
All right. From Paul, in rural areas, customers almost always come outside and object. Then after explaining the process, they'll release the vehicle. Any thoughts on that being a breach of peace?
Yeah, and that's really the big issue here, right? If every time a breach of peace occurred, all right, and you just left, you can imagine the recovery numbers are going to plummet, because I'm sure it happens all the time in the field. Again, I guess it depends on how, if they've gotten violent or threatening violence. I think that's a no-go all day long. if they come out and you explain what's going on, first off, you identify who the debtor is. You're not talking to a third party. Obviously, that's a problem. But once you identify who the debtor is and you explain it to them, and then they're willing to let you take the car, I think in that circumstance, you're going to be okay. But as a general rule, I mean, an objection is an objection. So again, that's something, you got to train your agents on. They've got to be skilled at it. Some are better than others. Some can get that vehicle. Other ones are going to leave it. And in a lot of cases, the debtor is going to continue to object. And it's obviously a no-brainer at that point. You leave it and you go to fight another day.
All right, there seems to be a conflict between local municipalities that state once a vehicle is moved to the street, the repossession is considered complete. Which should the agent follow to avoid issues?
Right. Well, here, I'm not aware of any municipalities that have, there may be reporting requirements. For example, in some cases, you always report the repossession to law enforcement, that local jurisdiction. So, the debtor doesn't come out in the morning and say, my car's gone and report it stolen. There's also some municipalities jurisdictions that require you to call ahead of time before you take the vehicle. And obviously each agent or company is going to be aware of those, or they should be aware of those. But otherwise, I'm not aware of any statutes that this person's inquiring about. They're not municipal statutes. There could be some state statutes, but not in every state. But the guiding thing here is really federal law, because most of these cases, a lot of the, not all of it, but most of the litigation is in federal court, because a lot of these go under federal law. I mean, to explain a little bit better too, you have the Uniform Commercial Code, which is a federal code, which all this case law is based upon. But each state has modeled the same statute under their state law. So you can proceed under state law, under the local, or under the state UCC language, or you can go federal. So I'm not aware of any statute that would require that in a municipality. Not to say there couldn't be one out there. If there is, those companies need to be aware of it and abide by it.
Why is accidental damage to a unit considered a breach of peace?
Well, because let's go back to the definition. You've breached the peace, the tranquility, the area. You're not, because it could lead or incite violence. So the debtor comes out and he sees you've ripped off his fender. He's most likely going to be pretty pissed off. He's going to start yelling at the agent, and there's your breach of peace. So in the whole context, you got to remember the context of repossession. It's about the potential for violence, and that potential continues until you get the vehicle back to your lot or further enough away where the courts will say that's not a breach of peace. So that's the rationale behind that.
Mark, didn't that initially come from case law that you researched too, that it was found?
Yeah, all these are from case law.
I was shocked myself when I saw that, as Jeremy put it, accidental damage was caused, and then that was found to be a breach of peace. I mean, I think it's incredibly unreasonable, but it's just something that's been found in case law.
Yeah.
So it can be avoided. I think it's important to train your agents to try to, complete the repossession with as little to any property damage as possible.
Right. And I started the whole presentation with the caveat that a breach of peace is going to occur. The creditor can do self-help repossession so long as they don't breach the peace. So whether it's damaging the collateral, damaging the siding on a house, turfing the lawn, ripping the bumper, off the car, that's all under that umbrella of a breach of peace.
So does that mean that damage complaints could be considered breach claims for lawsuits?
Absolutely, they can be. And there's a lot of inherent risk in this industry, as we all know. There's always a threat of violence, mostly from the debtors to our agents, of course. Obviously, we saw the opposite of that. There's some agents that get aggressive and make it worse. But that's just it's a tough industry, and these laws and these rules are tough because it decreases your chance of success if you think about it. There's all these rules to abide by. And I remember going back to the part of that last question, when I first started Relentless, I would have agents tell me, well, when it's on the hook, it's ours. And I would say, well, what's your authority for that? You know, what are you basing that upon? What Joe repo guy told you when you first started working there, that there is no consensus in the industry or under the law that once you hook that vehicle, it's yours. And it's certainly, you know, and you pull it out to the street to strap it down, it's not a completed repossession. We talked about that earlier. The further away you are from the location, the better off you are. When you're at the lot, you're golden. And it's under that same premise that the risk of violence continues until that repossession is completed.
If a breach is defined as any disturbance or escalation involving the police or customer objections, how can entering an apartment complex by tailgating be considered a breach? If there's case law, to your point.
Well, if it's back to this, if it's a secured, if it's got a gate and a code,
Trespass.
it's going to be a trespass.
Okay, all right.
That's why it's going to be a breach of peace.
Gotcha. Bear with me, y'all. I am flipping back and forth between the chat and Q&A, trying to keep it in order. Florida Statute 493, a repossession is complete when a licensed recovery agent is in control, custody, and possession of such repossessed property. Property that is being repossessed shall be considered to be in control, custody, and possession of a recovery agent if the property being repossessed is secured in preparation for transport from the site of recovery by means of being attached to or placed on the towing of other transport vehicle, or if the property being repossessed is being operated or about to be operated by an employee of the agency. Considering the statute, can there still be a breach of peace after control, custody, possession, and ready for transport?
Well, we here in Ohio, we've been working on some legislation that has similar language that, you know, the repossession is complete once it's hooked. Now, I'm not in Florida. I don't practice law there, but the first question I would have regarding that statute in Florida, has it been challenged in state court and has it been upheld? If it's gone to the Florida Supreme Court or other appellate courts that have ruled that the repossession was complete based upon the language of that statute, you're going to be okay in Florida. But on the other hand, as I talked about earlier, you've got state law and you got federal law. You go to federal court, and I'm not sure what district courts would be in Florida, but if the federal court doesn't have that interpretation, they don't have to follow Florida law. So you could be okay in Florida hypothetically, but if you're sued in federal court, they may dismiss that statute and say no and go back to the law I've talked about from all kinds of jurisdictions. The further away you are, the better off you are. So again, whether or not that's going to hold up, I mean, in a perfect world, that would be perfect for the industry. It's hooked, it's yours, no breach of peace. But I don't think we're going to get there anytime soon. And the only caveat to that would be, has that law been challenged and upheld? And if yes, great for the agents in Florida, unless you get the federal court, and then that may not apply at all.
All right. So for reporting being the deciding factor to complete if reporting is the deciding factor to complete the repo in my area, I don't know why we couldn't just report it, then hook it. Repo complete, no breach of peace. Is this why they're looking for hooked, moved off property to public place or property, then repo is completed?
Well, I'm not sure I understand the intent of the question, but if it's, you know, obviously there's a reporting requirement. You've got to notify local law enforcement because you don't want them to believe, you don't want them looking for a stolen car, and they're not going to be able to sell a stolen car. A car that's listed as stolen, they're not going to be able to sell at auction, and your lender's not going to be too happy about that, or the auctions are. But
Michael Payton,
I think the fact that you're reporting it to police has no bearing on whether or not the repossession is complete. Yeah, you know, you could be a block down the road and the debtor shows up, you've reported it, you're a block down the road, and the debtor says, give me my collateral back, drop it. If you don't, that's a breach of peace. You're still going to get sued. The fact that you reported it to law enforcement doesn't matter. Now, if you're back at the lot, you're fine. If they show up at the lot, you're fine. If you're 10 blocks away, 10 miles away, you're probably fine. But that's not dispositive, notifying law enforcement that you just recovered a vehicle and give them the VIN number. That's not your safety not to get out of there.
All right. Thank you for this great webinar. It's unfortunate this is where we've landed, but appreciate your knowledge and guidance on the growing issues with agents as well as consumers. Are you finding clients are willing to put this verbiage in contracts stating stating pay will be granted if the vehicle is left to prevent breach of peace, as well as paying? Not sure if that's correct.
Yeah. Well, right now, I think we're in the infant stages of this. This is something I think we started about 6 months ago. And, part of this seminar today is to educate the industry on it. As a matter of fact, we're going to do the same presentation at Used Car Week in Arizona in 2 weeks, or actually less than 2 weeks, I believe. But that'll be our chance, because it's going to be a bunch of lenders there. That'll be our chance to really educate some of them on this issue. And also, we're going to, present it in a little different way to them than we would to the industry here today. So I think that's a starting point. Ideally, yeah, it would be great to have it in contracts. I know over the last 3 or 4 years as an industry, we've demanded, mutual indemnification clauses. We've obviously demanded better recovery rates and things like that. So eventually, I would hope that, yes, once we get them educated and on board, that's something we could put in contracts. With if you go back to that slide that Amy's will share with anybody that needs it, we've limited what we consider a breach of peace to drop it and be compensated. It's not going to. We don't want to incentivize agents just to leave the second they show up because they think they're going to get paid. No, it's got to be they drove off the hook. They got between the boom and the car. Law enforcement showed up. There was violence, threats of violence, or guns. Those are the core things in regarding agent safety we're really concerned about, and we're mostly concerned about our agent safety versus payment and recoveries in those situations. So yes, but ultimately it would be awesome to put this in contracts with these limited scenarios that justify compensation.
You know what, I know that there's been press releases and cooperation. Just off the top of my head over the past year, PK Willis stands out as one, Resolvion is another, that if you properly report it, then you'll be compensated for it. I think it's really important that when you're having your scorecard calls or when you're having a touch point meeting with your clients, raise awareness of the fact that this is your company policy and make them aware that you're compensating your agents for a full repossession if they have to leave the vehicle, if there's a threat to their safety, or if they're preventing a breach of peace. So make your clients aware of it ahead of time so that if you have to ask for compensation on it, they're already aware that this is your company policy and that you're willing to pay your agent the full repossession.
Thoughts on objection after keys have been surrendered?
And well, I'll add to it. So I'm assuming the vehicle is still in the driveway or at the place it's being repossessed. I think the fact that they've objected after they've handed keys would work to be an objection and would be a breach of peace if you take the car at that point. Just like, it's the opposite of they objected, but you talked them into letting you take the car. In this case, they've handed the keys. It seems like, maybe they clean the car out and they decide, no, you know what? I need to get to work tomorrow. I want my car. Don't take it. If you take it, you're going to have a problem.
And that would hold true if someone's chasing you down the street.
Again, I think if they have regrets to what they've done and they try to chase you down, it goes back to how far away are you? Mm-hmm. Are you on the highway 10 miles down the road, or are you almost back to the lot? Again, it's going to be fact specific. That's what courts are going to do. They're going to look at the facts. They're going to determine whether or not you're far enough away and the debtor's objection is no longer a breach of peace. So And you got to think too, you're on the roadway or the highway and they're chasing you, you don't want to be chased by a debtor. Creates a safety risk, not only for the parties involved, but other people in the area. And, it's just not a good thing.
If the repossession is not complete until the unit has reached the property, does that mean that the debtor can pull up on the side and tell us to drop it, and that's what we have to do?
Well, again, I hate to be repetitive, but how far away are you from the scene of the repossession? Again, it's going to be fact specific, case by case. Maybe one jurisdiction it's not far enough away, another one it may be far enough away. I know that's not the answer people want to hear, but those are the answers we have. What we do know, though, is the further away you are, the better off you are. And we know if you get back to the lot, it's too late. It's no longer a breach of peace. So,
yeah, I think those are all the questions we have. The few questions we have left are specific scenarios that are some variation of what you've already covered. So I think it's safe to say that if you have specific scenario questions, then reach out to your legal counsel.
I do have one that I just saw come through that I did want to address from Mike. It says, what should an agent do when the person comes out and jumps in the vehicle, not knowing if that is the debtor or just the person who's been driving the vehicle? Can this person that is not the debtor file a breach of peace? Mark, I wanted you to address that.
yeah, well, it would be a breach of peace. So if you remember, we talked about this earlier, third parties can object just as well as the owner could. So I think in that situation, it doesn't matter. I mean, it doesn't matter if it's a debtor, it doesn't matter if it's a neighbor, it's the wife, the non-signer on the account. If they're objecting and they're in the car, you cannot take it. I mean, how are you going to get them out of the car? You're going to use force to get them out of the car. I mean, you're just going down that tunnel into a big hole in the ground if you're doing that.
Okay, well, everyone.
One other thing, Tony, I wanted to say.
Yeah, please.
And this is what I want to educate the lenders about the next week, and I want our people to know in the industry this. There is a website, or it's a platform. It's called the oh my God, National Consumer Law Center, and it's for plaintiffs' attorneys, and it's consumer law based, and they have all these resources for these attorneys when it comes to repossessions, wrongful repossessions, even regarding the lender's notice requirements when a vehicle's been repossessed and when it's going to be sold at auction. So they have all this information at their fingertips to come sue you, to come after you. They have all this case law that I'm talking about right now, all these scenarios, all these facts. That's how organized they are collectively. And, I'm sure, unfortunately, one, if not probably everyone that's in this seminar, their company may have been sued at least once or more on a wrongful repossession. And I just want people to understand there's things out there that educate these lawyers, or that they contribute to, that make them very good at what they do and come after you when you don't abide by these things. So I think it's important to know that. And I think it's important for the industry, the lenders, to know that when we meet with them next week. I've gained a lot. This is a good resource to have because it takes you right to the areas you want to have information about.
Mark, can I put it in the chat real quick? Do you know the exact website?
You're going to have access to it.
Oh, okay.
I have access to it because I'm a member of the Cleveland Law Library, so they pay for this. But yeah, they have their NARS every year, if you will. They go out and do their conventions and meet and talk about these issues and lawsuits and repossessions and everything. So it's just something out there that I want everyone to be aware of and know. I mean, this is serious business, and it can be very expensive and put you out of business if your employees aren't adhering to these rules, aren't trained properly, and don't understand really how this works. It's just a matter of chance when your number is going to get called if you're not training these guys right.
Hey, Mark, one more question. if a vehicle is stolen off the lot and the agent knows it was the owner, what can be done?
Well, obviously you make a police report. Hopefully you have good video footage at your lot that may capture this person. Usually they use their own set of keys. And, I guess it's going to be contingent on, what police department's investigating it and how far they want to go. Unfortunately, believe it or not, I think unless you can identify that person through, photographs or video, they may very well not go after them. They may not, you can't prove who was driving the car away, they're probably not going to prosecute. And, the tail end of that is the lender's going to want their money for that car that was stolen off your lot. So I know that obviously you have to notify your client immediately that the vehicle was stolen. They're going to want that police report. And I think within 30 days or less, they're going to want you to turn it over to your insurance provider to pay for it. I know what we do at Relentless is we'll, put it back into RDN and hopefully scan it with plates if the plates are still on it, or still look for the car if we can, or where it was recovered from. But, they're going to hide it or take it somewhere else. And we have been lucky in the past to recover these cars when they have been stolen off our lots. But it's just one of those things, the cost of doing business, unfortunately.
Okay. All right. Well, everyone, thanks for being here. Amy, Mark, thank you for taking the time. Just based on the engagement, looks like everybody this was great information. So we appreciate that. I just wanted to remind everybody, I'm going to share my screen. If I can take this back real quick, guys. Just a reminder that the deadline for nominating the nominations for NARS 2025 Industry Awards ends tomorrow night at midnight. So if you haven't nominated someone that you believe has done a bang up job in promoting the industry this year, please take a few minutes and do so. Just go to reposummit.com/industry-awards and take a couple of minutes. We'd really appreciate it. So with that, we'll give you back an extra 6 minutes, and we'll be sending out the replay probably within the next 72 hours or so. Everybody, thank you, and we will see you next month for ARA's Continuing Education Series webinar. It's actually going to be a year in review with Vaughn Clemens. Okay, everybody.
Thanks, everybody.
Thanks, Tony.